Major breaking news in the federal criminal trial of Donald Trump for his efforts to try to overturn the election results before and on January 6th. Tonight, the judge, Tanya Chutkan, has denied 2 Trump motions to have the government's case against him thrown out. Fair warning, if you happen to be watching from Mar-a-Lago tonight, the ketchup might be flying. Judge Chutkan begins with a robust takedown of the Trump claim that as a former president, he is immune from criminal prosecution. Here's what she says, quote, whatever immunities a sitting president may enjoy, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. Former presidents enjoy no special conditions on their federal criminal liability. Defendant may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office, end quote. Judge Chutkan goes on to explain why, in America, we have equal justice. Quote, the public has an undisputed interest in promoting respect for the law, deterring crime, protecting itself, and rehabilitating offenders. All of those interests would be thwarted by granting former presidents absolute criminal immunity. Most importantly, a former president's exposure to federal criminal liability is essential to fulfilling our constitutional promise of equal justice under the law, end quote. And Judge Chutkan explained the difference between protecting a president in office from civil action, such as wrongful termination lawsuits or, let's say, replacing a cabinet member, and criminal activity. Quote, the rationale for immunizing a president's controversial decisions from civil liability does not extend to sheltering his criminality. Indeed, the possibility of future criminal liability might encourage the kind of sober reflection that would reinforce rather than defeat important constitutional values. If the specter of subsequent prosecution encourages a sitting president to reconsider before deciding to act with criminal intent, that is a benefit, not a defect, end quote. Judge Chutkan, by the way, it's a 48-page response, which is worth reading. She denied the Trump claim that to prosecute him in federal court would be double jeopardy, since he was already impeached and acquitted by Republicans in the Senate after January 6th. She echoed the understanding that Mitch McConnell had when he voted to acquit Donald Trump in February 2021.
President Trump is still liable for everything he did while he was in office as an ordinary citizen. Unless the statute of limitations is run, still liable for everything he did while he was in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
Judge Chutkan also ruled against Trump on his First Amendment motion. We're going to get to all of that in a moment. Judge Chutkan's decision tonight on immunity follows a federal appeals court decision this morning that ruled that Donald Trump can be sued by Capitol Police officers and members of Congress in civil court for his actions on January the 6th. The appeals court wrote, quote, in arguing that he is entitled to official act immunity in cases before us, President Trump does not dispute that he engaged in his alleged actions up to and on January 6th in his capacity as a candidate, but he thinks that that does not matter. Rather, in his view, a president's speech on matters of public concern is invariably an official function, and he was engaged in that function when he spoke at the January 6th rally and in the lead up to that day. We cannot accept that rationale, end quote. The appeals court also did not buy the Trump argument that January 6th was Trump executing his constitutional oath of office. Quote, President Trump maintains that his actions as alleged in the complaint fall within the outer perimeter of official presidential responsibility, entitling him to official act immunity as to all the claims against him. His primary argument is that his alleged actions leading up to and on January 6th were official presidential actions because they amounted to speech on matters of public concern. In the alternative, he submits that those actions were official because they came within his constitutional duty under the Take Care Clause. We are unpersuaded by either argument. We are unpersuaded by either argument. Joining us now is someone else who's unpersuaded by it, Democratic Congressman Eric Swalwell of California, because he specifically is one of the plaintiffs in a civil lawsuit against Donald Trump for January 6th that can now proceed as a result of today's appeals court decision. Also with us, Joyce Vance, former United States attorney and professor at the University of Alabama School of Law. She's the co-host of the podcast Sisters in Law and an MSNBC legal analyst. Welcome to both of you. Thank you for being here this evening. Joyce, you know I've taken to enjoying reading legal documents, right? And this 48-page document issued by Judge Chutkan, it's some good reading. Now, Joyce is doing that Star Trek Transformer thing on me. Okay, there we go. We got you back. Sorry, Joyce, we had a signal problem there. It's some good reading. Not only is it pretty easy to read, but she is very specific about why she is taking this decision she's taking, almost with an eye to the fact that anything Judge Tanya Chutkan does, or Judge McAfee does, or Aileen Cannon does, is going to end up possibly before the Supreme Court. She's laying it all out. She's saying, this is the way the courts look at it. This is the way the Supreme Court will look at it. This is what our law says. It's all pretty clear.
Yeah, I think that's right. This is a very clear opinion written with an eye to the appeal, because unlike many issues that have to wait until a trial for an appeal, defendants are entitled to appeal these sorts of immunity issues before a trial takes place. So this one will be off to the races pretty quickly. But Judge Chutkan writes forcefully, and the argument is essentially this, that former presidents are not above the law. She justifies that in the context of history, tradition, and case law. But that's it. Donald Trump isn't above the law. Americans are entitled to see anyone held accountable for criminality, including a former president.
Congressman, I want to ask you, good to see you again, by the way, twice this week. I want to ask you about the other part, the civil suit. Donald Trump's tried a lot of things today in court, and they were all expected things. For most people, they're technical legal matters, but none of them went his way, including the fact that people like you or Capitol Police can sue the president in civil court based on actions that he took on and leading up to January 6th. Were you expecting that decision, and what do you make of it?
Well, I brought the case, Ali, because I wanted accountability and this idea that no one is above it, not even the president of the United States. And now the federal district court has said that, and the court a little bit higher than them, just under the Supreme Court, has affirmed that. And what it shows is that Donald Trump is facing this tapestry of accountability, and it's being stitched together by civil and criminal cases all over the country. And perhaps as we go into this next election, that tapestry of accountability, where the rule of law and the Constitution is working, is a security blanket for our democracy. And so I do believe at the end of the day, regardless of how this case goes down in front of a jury or how the criminal cases go down, that the strength of our democracy is going to be that we went through this exercise, and Donald Trump's fate will rest in the hands of jurors who are his peers. And it won't be Trump justice, which is what he would exact on people, where he, as king, is the judge, jury, and executioner. It'll be American justice.
By the way, there are lots of references, Joyce, in Tanya Chutkan's references to kings and how presidents are not kings, and how the framers of the Constitution wanted to make that very clear. And in part of her decision, she also speaks to the separation of powers. And I'd like to read it to you, because it's one of those things that may come into play later, but it's very, very important about the case that Donald Trump was trying to make and why she didn't go for it. She says the fact that Congress has spoken by criminalizing the conduct with which the defendant is charged also highlights the separation of powers principle that counsel in favor of the court retaining jurisdiction over this case. Holding a former president absolutely immune would thus impinge on the functions of all three branches with respect to the criminal law. Congress's province to make it, the executive's prerogative to enforce it, and the judiciary's charge to apply it. What is the point she's making there?
So she's making a compelling argument to the Supreme Court, saying we value the separation of powers, but we also value the ability of each branch to perform its functions. And so she's telling the Supreme Court, if you reverse my decision, you will impair essential functions of government. She's been reading the Supreme Court's opinions for the last term in particular when they've been focused on the Founding Fathers' intent, on history and tradition. She says, here's American history and tradition for you, Supreme Court. Former presidents have to be held accountable just like everyone else. Trump can't be immune. And it's, I think, masterfully done because she's written an argument that will be appealing to the people that will hear it on appeal.
Donald Trump, Congressman, felt that this could be double jeopardy because he's been impeached by Congress. And that's why we played that piece of sound from Mitch McConnell, who said on the day that Donald Trump was not convicted in the Senate that Donald Trump still holds responsibility. He still can be charged in civil court. He can be charged in criminal court unless the statute of limitations comes out. You, of course, were an impeachment manager against Donald Trump. That has Judge Chutkan has held today what Mitch McConnell said that day.
She has. That doesn't let Mitch McConnell off the hook, by the way, because he could have led the effort to convict Donald Trump. We proved that case. Many Republicans joined us, and Donald Trump would not be able to run for president today or ever hold federal office if they had, connected the dots and had the courage to do that. That aside, what our case also shows, and what McConnell was referring to, is we will be able to as we do depositions and discovery, getting evidence from Donald Trump, we will learn more about what happened leading up to January 6th and on January 6th, what Donald Trump did and didn't do that caused January 6th. And by the way, all of these individuals who refuse to testify to Congress, including what Donald Trump refused to provide, will no longer be able to refuse. They won't have the privileges that they used to not come to Congress because this is a private civil case. And so they will be compelled to come forward. So we're going to learn a heck of a lot more about what happened leading up to January 6th.
Joyce, I want to ask you about another thing that was brought up, and that was the issue of campaigning. The idea, in fact, it came up in I don't know which case it was now, where the lawyer said, I think it's Georgia, McAfee, where the lawyer said Donald Trump can't be called upon to be at a trial while he's busy campaigning for president. It'll be election interference. And the judge says, well, what happens if he becomes president? And the lawyer said, well, he's not going to be able to be, he can't be tried, obviously, while he's president. So the judge says, basically, you want this trial put off possibly till 2029. Talk to me about this business of a former president campaigning to be president.
Right. So this is the Fulton County hearing today. And Allie, we heard Steve Sadow, who's Trump's lead lawyer in Atlanta, say out loud what I had been concerned we were going to hear. Because up until now, we've all had some comfort level that the Georgia case is something that Trump could not tamper with if he becomes president. What Steve Sadow said today is, Judge, you can't try my client while he's a candidate for the presidency. That would be election interference. And you can't try my client if he's elected president, because under the Supremacy Clause of the United States, that would be prohibited. So you would have to put this case off until he left the White House. Now, the judge, who I think is very good at holding his cards sort of close to the vest, didn't indicate whether he was buying either one of these arguments and where he might land. But now we see what the stakes are here. Right. These cases don't go to trial before the election.
And some of his own questions helped you get a sense of, this is often the case in whether it's oral arguments at the Supreme Court. Just listening to what the judges ask gives you some indication of how they're thinking about it. I want to talk to you a bit more about this case when we come back, Joyce. So please stick around. Congressman, good to see you again. Thank you for joining us. Eric Swalwell of California. All right, coming up, as we were just talking about in Fulton County, Donald Trump's lawyers said, and I am not misspeaking, that he might not be able to be tried for his effort to overturn the election in Georgia until 2029. Amy Lee Copeland joins us, and Joyce comes back on the other side of the break. All right, today, Donald Trump made his most concerted effort yet to evade accountability in Fulton County, Georgia. It was the first time Fulton County Judge Scott McAfee heard directly from Donald Trump's criminal defense team, including the lead attorney, Stephen Sadow, who said Trump can't be put on trial because he's running for president.
Can you imagine the notion of the Republican nominee for president not being able to campaign for the presidency because he is, in some form or fashion, in a courtroom defending himself? So the bottom line right now is I don't think we should set a trial date.
Of course not. And here's where Trump's ultimate goal in Fulton County became clear.
If your client does win election in 2024, could he even be tried in 2025?
The answer to that is I believe that under the supremacy clause and his duties as President of the United States, this trial would not take place at all until after he left his term of office.
Till after he left office? That'll be 2029. District Attorney Fani Willis's team responded to that outrageous proposition with a simple request to, quote, move forward with the business of Fulton County. As part of today's hearing, attorneys for multiple co-defendants argued that the case should be dismissed on First Amendment grounds.
This is it. This is the first time that a prosecution of this type has been brought in this country, as far as I'm aware. The reason these lawsuits haven't been brought is because the First Amendment says you can't bring them. We're going to allow the discourse. We're going to allow the statements, even if they're false, because somebody's false statement is another person's truth.
And here was Fulton County's response to that.
We heard from the other side that this is the first time a prosecution of this type has been brought, that it's unprecedented, and that may be true. But this is the first time a criminal enterprise has gotten together and tried to overturn the results of an election. So I don't think that's a particularly persuasive argument. This is the first time a case like this has been brought. There's going to be a first time a case under any statute or any situation is going to be brought, and that doesn't make it unconstitutional.
The judge there, Scott McAfee, has not yet ruled on the schedule of the trial or any of the issues argued today, but the timing of that trial is actually going to be remarkably important. Joining us now is Amy Lee Copeland, a criminal defense attorney and a former Georgia federal prosecutor. Joyce Vance is back with us. Thanks to both of you for being here. Let's talk about this for a second, Amy Lee. The concept of the trial in Fulton County, Fani Willis has said she'll be ready to go around August-ish, but because of issues having to do with the appeals on the federal trials, the judge did ask, how much time would you need if this trial could go earlier? And the lawyer said about 30 days, which means this trial could be the first one.
It could be, Allie. It could be any time between now and 2029, apparently.
That's right.
But the state, yeah. But when asked, the state said it would need about a 30-day jump to subpoena its witnesses. They'd had a trial run with that, with the Chesbrough and Powell trials that simply didn't go forward. So they're ready to go. But you also heard the countervailing claim of Eastman, who said, listen, I just can't wait around until 2029 to do it. And that led Judge McAfee down other roads, like, would this be tried as two buckets of defendants? Would this be tried as 8 defendants each and possibly Trump by himself? So we came out with a lot more questions than we had answers for about the timing of the trial after today's 6.5-hour hearing.
Let's talk about this First Amendment business, Joyce. In fact, not in this indictment, but in the Jack Smith indictment, I think it's the second or third page. It's very, very clear. Everybody needs to just dispense with this First Amendment thing. Everybody's got a right to lie. Donald Trump has a right to lie. He's got a right to lie about the election. He's got a right to lie about the outcome of the election. He can do this all he wants. He can pursue his remedies. But once he's pursued all those remedies, and he still feels like lying about it, he doesn't actually get to take action to overturn the outcome of the election. That's what Jack Smith has said. This is the Fulton County story. Are the First Amendment claims similar and related?
They are. These are the same sorts of claims. And we saw the judge in Washington, Judge Chutkan, who we were discussing earlier, dismiss these sorts of First Amendment claims. The same argument applies in Fulton County. When your words are an instrument used to commit a crime, they're not protected by the First Amendment. So if Trump said, to a random person on the street, put your hands up, I'm going to rob you, certainly those comments wouldn't be protected by the First Amendment. They would be part of committing a crime. Same thing holds true in Fulton County and in D.C. where speech is used to commit crimes, it's not protected. And of course, as the DA's lawyers were quick to point out, the reason that there's not been a prior prosecution has nothing to do with the First Amendment. It has to do with the fact that no president has ever been part of a conspiracy to overturn an election before this.
Interesting, though, Amy Lee, the Trump attorney did seem to be sort of floating this idea of alternative facts, right? The idea that one person's truth is another person's lie. There is some danger about these trials becoming trials around the First Amendment, despite the prosecution's efforts to dispense with the notion that these are First Amendment prosecutions, because they're not. Donald Trump, in his social media, in his speeches, wants to call them both First Amendment issues and election interference in both cases. And I suspect that's not going away just because a judge says so.
Of course it isn't. And to piggyback on Joyce's answer, I think it's interesting. I actually looked up to see what the ACLU's position was, and a few weeks ago it published an op-ed saying that it, a staunch defender of First Amendment rights, who had actually defended Trump various times, including being upset that he got kicked off social media for exercising those rights. Even the ACLU has come out and said, you know, this isn't a First Amendment case. But go back to your question, you know, the real issue at today's hearing was exactly when could the judge determine these First Amendment issues? Did he have to wait until during trial when the evidence started coming out, or was there any avenue that he could determine them prior to trial? And for the first time today, the defendants floated that there was a case that they found from Georgia that said that the judge could actually determine these issues before trial. So there was a lot of hullabaloo about what would the defendants have to stipulate to have the judge determine this. Ultimately, though, this isn't going to be a successful claim. I mean, this is not a First Amendment case. The rubber meets the First Amendment road when talk turns into action, and there was plenty of action here.
Joyce, you and I talked in the last block about what Scott McAfee said about, we heard it, the exchange about when Donald Trump is running for president and when this can be tried. Tanya Chutkan had a conversation about this as well today, and she released information in her decision earlier about campaigning. And I want our viewers to compare what they heard in the Fulton County Court to what Tanya Chutkan wrote. She said, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of the office. Tell me how that thinking applies to what we're hearing from Donald Trump's attorneys about the fact that he can't be tried while he's campaigning, and then he certainly can't be tried when he's president again, if he's president again.
So that's a really interesting question, because that's extending the analysis a little bit further. The argument that Judge Chutkan has made is that President Trump might be entitled to certain immunities, but candidate Trump is not. Candidate Trump is responsible for his conduct. And so there's an interesting question of whether status as a candidate means that Donald Trump can't be put on trial. That will be a question that perhaps Judge McAfee will have to sort out. It was interesting because he extracted a concession from Steve Sadow. He said, if your client is not the Republican nominee, then nothing prevents him from going to trial, right? And Trump's lawyer was forced to acknowledge that that was correct. That doesn't mean, though, that Trump is able to avoid a trial just because he's a candidate. And there will be good arguments offered by the district attorney for taking him to trial, regardless of whether he's a candidate or not at the time.
Thanks to both of you. I'm always grateful for your analysis, Amy Lee Copeland and Joyce Vance. All right, when we come back, it took nearly a year, but today, the House of Representatives finally voted to expel George Santos. No thanks to House Republican leadership, by the way, with every single Republican leader voting to keep George Santos on the job. Democrats are really the ones who cleaned up this Republican Santos mess. Congressman Glenn Ivey, a member of the House Ethics and Judiciary Committees, joins me next. Why would I want to stay here? To hell with this place. That's what George Santos told reporters after he became the 6th member in the House of Representatives history, 234-year history, to be expelled.
The chair announces to the House that in light of the expulsion of the gentleman from New York, Mr. Santos, the whole number of the House is now 434.
And with that, Congress and the Chaos Caucus is down one member. But this Republican House remains full of bad actors, even though its most outrageous pretender is gone. 105 Republicans joined 206 Democrats to remove the indicted Republican congressman. But new Republican Speaker Mike Johnson and his top lieutenants, Tom Emmer, Steve Scalise, and the New Yorker Lee Stefanik, were not among them. And on the same day that Speaker Johnson voted to try to save George Santos, CNN reported this. Mike Johnson wrote the foreword and publicly promoted a 2022 book that spread baseless and discredited conspiracy theories and used derogatory homophobic insults. The book also disparages poor voters as unsophisticated and susceptible to government dependency and easy to manipulate with Black Lives Matter, defund the police pandering, end quote. A spokesperson for the speaker said that he, quote, had never read the passages highlighted in the CNN story, with which he strongly disagrees. Baseless and discredited conspiracy theories, by the way, is not categorically something the Republican House has shown to have any problem with. See, because pretty much every so-called weaponization hearing that has flopped. It's going to get worse or better now that Speaker Johnson now leads a Republican caucus with only a 3-member majority. Joining us now is Democratic Congressman Glenn Ivey of Maryland. He's a member of the House Ethics Committee and a House Judiciary Committee. He's also a former federal prosecutor. And also with us is the congressional historian Norm Ornstein. He's an emeritus scholar at the American Enterprise Institute. Gentlemen, good to see you tonight. Thank you for being with us. Norm, for people who've been following this, there's been an interesting evolution. There were particularly some Democrats, including Jamie Raskin, who earlier, when this vote was first taken, voted against the expulsion of Congressman Santos because he said, we don't really want to have emotions guiding how we do things that are that important in Congress, especially when you expel someone who is not answerable to you. They're answerable to their constituents. So he wanted to hear the evidence from the Ethics Committee. You, like a lot of Americans, were skeptical that the Ethics Committee would sort of do its job because sometimes it just doesn't in Congress. Tell me how that all unfolded.
So the Ethics Committee, the best word I could use for its performance over the last number of years is feckless. It rarely takes action against other members and often divides along partisan lines. When the Ethics Committee issued this report unanimously, and a scathing report built on evidence of fraud and misuse of campaign funds and serial wrongdoing by George Santos. It went way beyond, his own lying about his identity and his background. That changed things. Jamie, I rarely disagree with, and I don't in this case. He was right in the first instance that you want to be careful about turning expulsion into a tool that you use more regularly than it has in the past. It's a very powerful weapon. But in this case, yes, it was the right thing to do. And one thing I should note, Ali, is that I'm hearing a lot of talk, well, we've never expelled anybody who has not been convicted of a crime. The 3 Confederates who were expelled around the time of the Civil War weren't convicted of anything. They were flat out insurrectionists trying to destroy the Union. And that's why we ought to take a look at some of the Republicans in Congress who are flat out insurrectionists and tried to destroy the Union.
Glenn Ivey, you were one of the people on the ethics panel that and wrote this stuff, and it definitely blew people's minds. I don't know what they were expecting. I don't know what you were expecting to write, and I do want to hear your take on what Norm just said about the fact that some people felt that the standard for expelling him should be criminality. In fact, that's what George Santos himself said in his defense. He said, "I've been convicted of nothing."
Yeah, I think that's right. We had a number of people, even in today's vote, who felt that they couldn't vote in favor of expulsion because he hadn't been convicted of a crime. But the point that I tried to make was that the Constitution doesn't require that. It's a 2/3 vote is the only requirement in the Constitution. We don't have to wait until a member's been remanded to the Bureau of Prisons before we can vote him out of the House of Representatives for this level of misconduct. And I think the other points to make, as Norm mentioned, it was unanimous, it was bipartisan, the report coming out of the Ethics Committee. I think the other piece that we should note here is that there was really no dispute with respect to the findings that we made. Mr. Santos gave a lot of interviews, made a lot of statements, press conferences, just statements on the floor even. but he never challenged any of the factual allegations that we raised in the report, or for that matter, that were raised in the indictment. So essentially the findings were undisputed, and I think that led a lot of people to change their votes from where they'd been in the last vote. The last thing I heard, too, was, and I wasn't aware of this until recently, but apparently there was a Republican member who was a victim of the, credit card scams that Mr. Santos was involved in, and sent an email to his Republican colleagues to let them know that. That's a pretty powerful affirmation of the report that we issued.
Yeah, he said he and his mother were done out of some money by George Santos. It's a remarkable read, the Ethics Committee report. Norm, you made a point about the fact that the reason you agreed with people like Raskin and on both counts is that expulsion from the House is serious. And that's sort of hard to express to people because a lot of people are frustrated with what goes on in the House of Representatives and they're not sure how effective it is. But this is important. People have a right to be represented there and represented well. I want to play for you what Speaker Mike Johnson said, because he's sort of making the point that Republicans are the ones who take all these serious things seriously. Democrats are the ones who weaponize them. Listen to what he said.
I served on President Trump's impeachment defense team twice. And we lamented openly, and we decried how the Democrats politicized that process. They were brazenly political, and how they brought those meritless impeachment charges against the president. This, what you're seeing here, is exactly the opposite. We are the rule of law team. The Republican Party stands for the rule of law.
Kind of made my eyes bug out a little bit, Norm.
Mike Johnson is not going to go down as one of the better speakers of the House, and he is not wearing well in his short time in office. Of course, the impeachments of Donald Trump, both of which were joined by some Republicans, were built on a very strong base of knowledge and of facts. And it's pretty clear that Mitch McConnell almost joined in the Senate with the conviction in the second impeachment. Didn't do so because he feared it would divide his own Republican base. But, there's one other point here that's worth making, Ali, and that is censure is the next level of punishment in the House. And it used to be really serious. If you are censured, which takes a majority, you have to go into the well of the House and the charges against you are read. It's humiliating. Well, we've defined deviancy down, and what Republicans did was not the rule of law when they censured Adam Schiff. They censured Adam Schiff because he had been too effective in the impeachment of Donald Trump. So they've debased censure, and that doesn't leave a lot of additional punishments. And we have to start looking in a different way at what we can do when members go over the line. And they're going to go over the line now, it's very clear, with an attempted impeachment of Joe Biden, which itself is utterly meritless.
Guys, I wish I had more time for this conversation, but I thank you both for being here tonight, and we'll continue it. Glenn Ivey, Congressman Glenn Ivey, thanks for being here. Norm, always good to see you. I'll probably see you again in a few days. All right, coming up, the collapse